from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to part 4 of our series entitled The People's Law School, Know the Law. In this 4th program of this series, we're going to be discussing consumer law, landlord-tenant law, government benefit programs, and legal aid. In order to accomplish our desire to discuss these important sub-areas of law, I welcome to the program Alan Wasserman, who's an attorney in the state of Idaho with offices in Coeur d'Alene. Mr. Wasserman, we are very grateful to you for helping with this whole series, both at the college and the course, and the series we're doing on TV. I know you and Sue Flamia have worked very hard to coordinate this, and we appreciate that effort as well as being on today's program.
Well, thank you for having me.
And I'm always pleased to have our 2 regular panelists. First of all is Janelle Burke, who is an attorney in the state of Idaho and a law clerk to a judge in the 1st Judicial District. And next to her is Steve Schenck, who is the Dean of College Relations and Development at North Idaho College. And I shall ask Janelle to commence today's questioning.
Alan, it's a pleasure to have you on the program. You're widely known and well respected in your profession and among the people who think of you as a legal services attorney. Can you tell us something about legal services? Give us a broad overview of what legal services actually are.
Well, when people speak of legal services these days, they generally are referring to programs that receive money from government agencies and in return provide free legal services to low-income people. Idaho Legal Aid Services Incorporated technically is a private nonprofit Idaho corporation, but we in turn receive most of our funding from the federal government, the Legal Services Corporation, which is funded by Congress, and then we in turn provide free legal services to low-income Idahoans within certain limitations, of course. And there are about 300 legal service programs throughout the country receiving these kind of funds. In some areas, legal service programs also receive other sources of funding to complement the federal funding. For example, here in Coeur d'Alene, and we receive United Way of Kootenai County funds to supplement our federal money. Unfortunately, we don't receive any funds from the state of Idaho, unlike many other states which do provide funding at the state level as well.
What kinds of people would come to you for help?
Well, we have to limit the services we provide because our resources are so limited. I've seen estimates that we can only meet about 15% of the civil legal needs of low-income people. So as a result, our board of directors, which we have, sets priorities. So the types of cases that we handle typically involve what we think of as basic necessities of life. So we're talking about, number one, people have to be financially eligible. That means their income and their assets have to be low enough. And secondly, they have to have a type of legal problem that our board of directors wants us to handle. So for example, landlord-tenant problems is a big topic that we handle quite a bit of. We also help people dealing with government benefit programs if they believe they've been improperly denied or unfairly treated benefits. In addition, as I mentioned a moment ago, we receive funds from United Way of Kootenai County that allows us to deal with domestic violence cases. And then in addition, we receive funds from the Area Agency on Aging that is specifically tailored to meet some of the legal needs of senior citizens, without regard to being low income, I should add.
Steve Schenck.
Alan, just out of curiosity, and since we have viewers in Canada, are you aware whether the Canadian legal system has anything that is similar to our legal aid system?
I'm sorry, I don't. I would be very surprised if there weren't. And in fact, I should say I'm quite sure there is a legal aid system, but I'm really quite unfamiliar with it. But I am quite sure there is a legal aid system available similar to what I was just describing for the United States.
I have another quick question to kind of follow up on Janelle's line of questioning. Do you carry your legal services through courtroom trials if necessary?
Yes, the services we provide are by and large the full range of services that any attorney could provide to a client. A lot of our work involves counseling clients on what their legal rights are, providing a brief service, perhaps writing a letter, making some inquiries, but it can go the full gamut and could involve going to court, and in fact often does, And we've had cases at all levels of the judiciary.
So appeals are also possible.
Absolutely.
Is it a sort of a partnership arrangement between the client, between legal professionals and that board that you mentioned to determine, yes, this is something we'll take to court, yes, this is something, if need be, we'll appeal?
Well, the board of directors doesn't get directly involved in those kind of decisions. They set the broad policies and types of cases that we can do. And I might add Congress, because a lot of the money comes from them, also sets limitations on some of the types of cases we can do. I might add, just parenthetically, a controversial restriction that's about to be imposed upon us by Congress is that we cannot pursue class action lawsuits, which was one of the many tools that have historically been available to us, like any other attorney, in representing a client. So yes, we represent clients in the full range of tools available to an attorney within some limits imposed upon us by our funding sources. But that decision is made by the attorney and the client as the need presents itself.
I'd like to get into a particular area of law that our viewers are always, I'm sure, very interested in what some of the details are. One of the areas that you have already identified is landlord-tenant laws, and not just confining oneself to Idaho and being very general, although I know you're specific to the law in a particular state. Kind of run us through a list of responsibilities and rights of both a landlord and a tenant. If someone is renting from someone, what should both sides expect to have a reasonable relationship?
Well, I view it as being helpful to view landlord-tenant law as more or less a system of mutual obligations and rights. And so on the one hand, a tenant, by entering into a rental agreement, whether it's written or oral, obligates themselves to, for example, pay the rent and to otherwise live up to the terms of the lease and not commit waste or destroy or damage the property. On the other side, the landlord, by agreeing to rent out property that he or she owns, agrees to provide what's called the quiet enjoyment of the premises. That means it's a peaceful place to live, that's habitable, it's safe and sanitary. And then the whole process of landlord-tenant law then develops when one side or the other believes there's been some breach or some violation of those mutual obligations and agreements. And to elaborate in Idaho, if a tenant, for example, believes that there is a problem with the premises, if the landlord has not kept up his side of the bargain, then the tenant has to bring that to the attention of the landlord through a written notice. Similarly, if the landlord believes the tenant has not lived up to an obligation, for example, has pets when they're not supposed to or hasn't paid the rent, then the landlord, at least in Idaho, is required to put the tenant on notice in writing to give them an opportunity to cure that problem. And then it's only after those notices have been given and the other side given a chance to cure the problem that the courts then get involved. Because then either side has the opportunity to go to court to ask a judge to enforce the provision of the lease that's not being honored by the other side.
If a lease is broken, let's say by the tenant, and the landlord is going to evict the persons involved, there still has to be a written notice, or there has to have so much time?
Exactly. In fact, a very important point that I'd like to share with you and your viewers is that in Idaho, at least, a landlord cannot evict a tenant. Only a judge, only a court may evict a tenant. And as hard as it is for some landlords to accept that fact because they feel they own the property and therefore should be able to dictate when and how people come and go, nonetheless, the law is quite clear. They have to provide a written notice, give a chance to cure the problem, and if the problem is not cured, then they have to go to court, sue the tenant to ask a judge to order the eviction.
Let's suppose that a lease has run out, or there's an ongoing 30-day lease. Then at the end of that time, a landlord can notify a tenant that on a certain time that they are to move. Is that correct?
That's correct. But even in that situation, if the tenant does not honor the landlord's notice to leave, the only option available to the landlord is to go to court to ask a judge to evict the tenant. And technically what happens is the judge will issue an order and the landlord can then take it to the sheriff's office to have that order enforced.
It must go through that legal channel.
Right, so it's very important that a landlord does not have various other options that people sometimes think they can use. For example, they cannot lock out a tenant, they cannot have the utilities shut off, they cannot take any property of the tenant, nor can they have the tenant arrested. All they can do is go through this process of seeking the court's intervention.
Janelle Berg.
Let's talk a little bit about the tenant now. Suppose that the tenant believes that the place that he has or she has rented is not quite up to standard. What can they do? Or they have a problem over time.
Well, again, their obligation is to bring this to the attention of the landlord by, in writing, giving the landlord an opportunity to cure the problem. If the problem is not cured, the landlord then can be brought to court to have a judge either order the landlord to make the necessary repairs or to pay monetary damages to the tenant. But significantly, the tenant may not withhold rent as a tool to gain leverage over the landlord. If the tenant were to do that, the landlord would be free to simply turn right back and issue a 3-day notice for non-payment of rent. And a very important distinction in this whole process of mutual notices and going to court is that in one particular case, it goes to court very quickly, at least under Idaho law. If the landlord believes you haven't paid the rent and has given you a 3-day non-payment notice, then if starting with the 4th day he sues to have you evicted and get possession, it goes to court within about a week. Whereas all these other situations, if it's violating the lease by having pets, for example, or if it's the landlord has not made some repairs, it could take several weeks or even a month or two to go to court. But the landlord has that ability for a very expedited proceeding if it's for non-payment of rent. That's a very critical point.
My next question has to do with kinds of leases, and then would you follow that up with some advice from you for people who are about to enter into leases? What should they not do?
Okay.
Or what should they do
Okay.
conversely?
Okay. Well, there's no magic formula for a lease. A lease can be oral in Idaho. It can be written, and we see all forms and shapes of written leases. They can be for month to month, written or oral, or they can be for a period of time, a fixed period of time. Obviously, whenever someone enters into any obligation, whether it's a landlord-tenant arrangement or some other arrangement, they need to understand what they're getting into. So if they're going to be signing a written lease, obviously they need to read it and understand it. If they have questions, they need to ask. If they disagree with a provision, they need to point that out to the landlord in hopes of getting it changed. Perhaps some practical advice to offer people is when they first enter into a tenancy, it's a really good idea to go through the entire premises, preferably with the landlord and possibly even a friend who could later be a witness, to see what kind of problems, what kind of damage already exists, in hopes of avoiding the situation where when you later leave, say 6 months, a year later or more, the landlord tries to hold you responsible for some pre-existing conditions. By the same token, at the end of a tenancy, it's a great idea if the tenant invites the landlord to go through the premises after it's been cleaned and everything's moved out, to try to reach some agreement that yes, everything is as it should be. At the very least, the tenant should go through on their own with a third-party witness and have that witness available later in case the landlord tries to claim there are damages that did not occur.
Steve Sheen.
Following up on that quickly, is it a whole different set of law and remedies that are available after the fact? Because that seems to be one of the common areas of complaint you hear about are these exit problems. I won't refund your security deposit. There are damages here. You didn't clean the property thoroughly. What remedies do you have at that point?
Well, you're absolutely right. That is a big area of contention between tenants and landlords. And there we're left with the regular civil remedies of if you believe you've damaged my property and owe me money, you're going to have to sue me. Small claims court in Idaho is available for cases up to $3,000, and that goes both ways. A tenant who believes their security deposit was improperly withheld, after giving the landlord an opportunity to either provide an itemized list of why the money was withheld or give them a chance to give the money back. If neither occurs, they have the ability to take the landlord to court, preferably small claims court, because that's a lot simpler and quicker than to go to regular magistrates court, at least here in Idaho.
In all these situations we've talked about that unfortunately might end up in court, does either the tenant or the landlord have the right to ask for legal fees as part of the settlement?
Yes, at least under Idaho law, there are specific provisions that allow the prevailing party to recover attorney's fees from the losing side. And very often, even in the absence of that provision, there are provisions in leases that specifically call for that as well.
Are jury trials common, or are they not even an option? Are these a judge and...
No, a jury trial is definitely an option. I don't think they're common, but it is an option.
Because of the expense involved? And what about other forms of damages? Are those allowable under tenant-landlord law?
What do you mean other
punitive
form?
Damages or...
Well, if you can show that a party has acted outrageously, the statute does provide for what's called treble damages in Idaho, a tripling of damages if a landlord has acted outrageously. And I'm quite sure in similar jurisdictions, if you can show some kind of outrageous conduct, you have available to you punitive damages over and above your actual damages.
And a quick final question, if I can, Tony. Do you often, in your work through legal aid, get involved after the fact? It's not uncommon to hear about damages being awarded in small claims court, but then the problem of collecting those damages can come about.
Okay. Before I answer that question, let me just add that I view our main role in legal services in helping landlord-tenant disputes is making sure that people follow the rules. Mm-hmm. I mean, our biggest concern is that if a landlord believes they're being treated improperly by the tenant, that they follow the rules that are available to them. And that's our main role, I think, is making sure and holding both sides accountable to the rules. But to answer your specific question about dealing with after the fact and how do you collect on a judgment, that raises a whole other subject that we can talk about, and that is how do you collect on any judgment mm-hmm. once you've obtained the money judgment. And there are various tools available to the judgment creditor, the person holding the judgment, just as there are various protections or exemptions available to the debtor, the judgment debtor, in this case perhaps the tenant who has a judgment against them for damages mm-hmm. To the premises that they used to live in. If you like, we can talk about that a little bit, or how those exemptions work here.
Is that too far afield? So if you would, just go through briefly some of the major tenets of those.
Well, the major processes that we've been talking about is someone, like say a landlord or any other creditor, gets a judgment after taking the person to court. They've had their day in court, mm-hmm. and for whatever reason they've lost. They now have a judgment against them. The judgment is then taken to the sheriff. The sheriff is asked to execute on that judgment. And in doing so, they are then allowed to take property of the person against whom the judgment was obtained. However, there are important limitations on doing that, called exemptions. So obviously the easiest thing for the sheriff to do would be to just take money out of the judgment debtor's bank account, or to go to their employer and garnish part of their paycheck. But even there are limitations on what the sheriff can do to collect or execute on a judgment. For example, with wages. At the most, only 25% of the employee's take-home pay may be garnished. And even then, that much cannot be taken if they would be left with less than 30 times the minimum wage in take-home pay. So if someone has a relatively low-paying job, their wages may not be subject to execution even if there is a judgment against them. In some judgments, it's 40 times minimum wage take-home pay per week.
Hourly minimum? Is that
Correct.
What we're talking about? Okay.
Right. And the example of bank accounts, depending on what funds are in there, they may not be touchable by the sheriff. For example, if they're public assistance funds or Social Security benefits, which are very often direct deposited into accounts, if those are the only funds in there, if they have not been mixed with other funds, then they're off limits to a judgment creditor trying to collect on a judgment. Similarly, one's vehicle is exempt up to a certain amount, and that amount varies state to state. In Idaho, it's $1,500 per person. If you're a couple, you can add those two amounts to protect $3,000 of equity in a vehicle against a judgment creditor. Household goods are also protected in varying amounts in different states. One's home is protected by a homestead protection, again, in an amount that varies state by state. In Idaho, it's the first $50,000 of equity, which of course is the difference between the fair market value and any debts or mortgages against property. So on the one hand, the judgment creditor has various tools available to garnishing wages, taking property, using the offices of the sheriff. On the other hand, there are various exemptions or protections available to the debtor. And significantly, at least in Idaho, the debtor has to claim those exemptions. And the process involves the sheriff seizing certain property and then the debtor having up to 14 days to claim the exemption, or else it's lost.
So the bottom line here really is that if two people have conflict and one has money and the other one doesn't, the one that is with money is more liable in judgment than those who are without funds.
Well, it's true that the more assets you have, the more vulnerable you are.
So even though you may win in court, you may not win anything if you're suing someone who really doesn't have anything.
Right, and there's the concept of being judgment-proof, and some people have so few assets that a judgment against them is of very little value.
And on unless they get assets.
That's correct.
I'd like to move to an area of what we describe as the general area of consumer law. And Alan, if you would take us again through in a most general way, federal legislation, or each state, as they have legislation, can you give us this kind of overview of what we try to reach in protection for the consumer in various products and sales?
Well, I could probably take the next few hours to
Yes.
talk about that, but let me try to just briefly summarize. There are a whole range of statutes now in effect that have been passed both by Congress and state legislatures aimed at protecting consumers from one form of abuse or another that have occurred historically. So, for example, we now have specific laws that deal with how collection agencies may collect a debt. It even limits the time of day that a person can be called, and it gives the debtor certain rights in dealing with the collection agency. For people who give credit or sell products on time through installments, we have the concept of truth in lending, which requires that the lender or the seller make certain disclosures so that the person who is paying a finance charge knows what that charge is going to be, and therefore is able to compare it to what other charges might be with other lenders or sellers. There is the Consumer Protection Act we have in Idaho, which generally protects against deceptive or fraudulent practices on behalf of merchants in selling products to consumers. So there's a whole range of statutes that have arisen over the years to address specific abuses. But there are a few things that people need to keep in mind. With all these protections, you're still by and large on your own, and you need to make a sensible decision when you're entering into some obligation, whether it's to purchase a car or to enter into a leasehold for a tenancy. For example, there are many misconceptions that people have in how they, in terms of protections that they do have that they don't really have. A big one is that people are always calling us and asking, well, don't I have 3 days to change my mind, to bring back the used car that I bought yesterday? I changed my mind. The answer, unfortunately, is no. There are some few instances where people have 3 days to change their mind. Typically, those involve door-to-door salesmen who come to your home unsolicited, or people who take a security interest in your home to secure payment of a debt. But aside from those very limited cases, if you agree to buy something, you can't change your mind. And the only way that you can get out of an arrangement like that is if you can show you were misled into entering into the arrangement in the first place, if the seller misrepresented some important information that you relied on. So in the used car sales example, there's not a whole lot you can do, especially in cases where the car is sold as is without any promises. And so there, the big practical advice to people is take a car that you're going to buy to a third-party mechanic and ask them to look at it. If the seller of the vehicle doesn't want to let you do that, you might want to think twice about dealing with that particular seller.
So you better do the research before you make the deal rather than trying to get out of it later in most cases.
Exactly.
The other question I have concerning the consumer has to do with buying products and there's from that or injury. We've heard of toys and different things. Even though you've bought it and made certain deals, if you can prove that the product itself has been produced in such a way it causes injuries, then there's another form of lawsuit that can be successful, is there not, under the laws?
Well, that's true, although we're getting quite far afield from what we do within legal services. One of the areas of law that we do not deal with are cases that are suing for monetary damages for personal injuries. But yes, you're right, there are statutes called product liability statutes that, and just in general, that have case law that has built up over the years that provides remedies to people who have been harmed because of the design or the manufacturer of a particular product. And that's a very important remedy for people, in my view, to have as a means of ensuring that products are carefully thought out and designed before they're put on the market.
And going beyond legal aid and what you're doing, I'm trying to also serve the other constituency that we have out there. In that area, if you're not going through legal aid, there's also been a lot of successful class action suits in those cases, have they not?
Right. And I should emphasize that although the types of cases that we within Idaho Legal Aid Services handle are limited, we do view ourselves as a referral, a source of referral information. So, for example, we maintain a list of private attorneys within our service area, which with Coeur d'Alene is the 5 northern counties of Idaho, of attorneys who will agree to talk to someone free the first time and give them some initial advice. There also is the Volunteer Lawyers Program within Idaho that tries to hook people up with private attorneys who have agreed to volunteer their time. And there are similar programs in other jurisdictions to handle those types of cases.
Janelle Berg.
We have a very short time left, but let's talk a little bit about debtor-creditor. What makes a contract, and when do people have to pay back the money?
Well, I guess the simple answer is when they agree to. I mean, if there's been some sort of agreement, there has to be an agreement between the parties. It doesn't have to be in writing. There are oral contracts that are just as enforceable. There has to be some basic agreement. There are two basic distinctions, or one basic distinction that people could keep in mind in dealing with debts, and that is whether they've given a security interest or not to the creditor. And they know they've given a security interest if they've actually signed a piece of paper giving a security interest in some item called collateral, typically. Only in those cases can the creditor take it upon themselves to repossess the property if the creditor thinks you've failed to pay. In all other cases, they need to take you to court, just like the landlord has to take the tenant to court if they believe they've been wronged.
On that note, we have to bring the program to conclusion. On behalf of our panel and our staff, Alan Wasserman, we thank you very much. This has been an excellent program, and I know our viewers have been informed on some very important issues. And I was particularly impressed where you were trying to lay to rest some misconceptions that people might be acting upon. I would also like once again to thank you for the helping put together the 9-week series that North Idaho College called the People's Law School. We had a sellout for that particular course. We even had people on a waiting list. And again, we thank you and Sue Flammey for your work in that, as well as this 6-week series of our television program. We are grateful to you. Ladies and gentlemen, I would invite you to be back with us again next week when we'll do part 5 of this series entitled People's Law School Know the Law. We hope this is most informative and helpful to you. And until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.